You've seen them, right? Picket lines. They're such a familiar part of any big labor dispute. But what if I told you that for a long, long time, the simple act of walking that line with a sign could get you thrown in jail? Well, today we're diving into the landmark 1940 Supreme Court case that totally flipped the script on picketing, turning it from a potential crime into a constitutionally protected right. It all started with one man and one protest, but it ended up becoming a cornerstone of American free speech.
To really get what a massive shift this was, you have to start right here with these powerful words from Justice Frank Murphy. His point was, look, talking about what's happening at work, the good, the bad, the ugly, that's not just some private chat. It's essential for a healthy democracy. It's something we all have a stake in. And that's the whole conflict right there. You have the Supreme Court on the verge of calling this kind of discussion indispensable. But at the very same time, a state law down in Alabama had made it completely illegal. You can just feel the constitutional showdown brewing, can't you? All right, so here's our roadmap. We're going to start with the man who kicked this all off, Byron Thornhill and his so-called crime. Then we'll see how his fight blew up into this huge free speech victory. But then we'll watch how that same right got slowly chipped away over time, which sets the stage for these major showdowns with presidents like Ronald Reagan and, much more recently, Donald Trump. Okay, so let's meet the guy at the center of all this. Byron Thornhill wasn't some kind of troublemaker. He was a union president, just doing his job. And he found himself on the wrong side of a very, very broad law, all because he decided to join a peaceful protest. So get this. This is all he did. Thornhill, the union president, is on a picket line during a strike. He walks up to another worker, a non-union guy, and just tells him, hey, there's a strike going on. That's it. The other guy listens and decides to go home. No threats, no violence, not even any yelling, just a quiet conversation. And for that, he got arrested. It's kind of wild when you think about it. Yep, arrested. Why? Because of this Alabama law, Section 348. And this law was just incredibly broad. It basically outlawed any attempt to even publicize a strike near a business. Thornhill was found guilty, he was fined, and he was even sentenced to jail time. But Thornhill didn't just accept it. He appealed his conviction, and that case climbed all the way up the ladder to the U.S. Supreme Court. And this is the moment a small-town labor dispute explodes into a national precedent for free speech for everybody. And wow, the court's decision? It was a landslide, an 8-1 ruling. They didn't just overturn Thornhill's conviction. They threw out the entire Alabama law, calling it unconstitutional. So, what was their reasoning? Well, they laid out a few key things. First, they said labor disputes aren't private matters. They're issues of public concern. And peaceful picketing? That's a form of public discussion, a form of free speech. They also pointed out that the Alabama law was just way too broad and could be used to punish pretty much anyone. And maybe most importantly, the state couldn't show that Thornhill's quiet conversation created any kind of clear and present danger that would justify shutting down his speech. I mean, this was a monumental win for unions, a game changer. For the very first time, peaceful picketing had the full-throated protection of the First Amendment. But, as we see so often with these big Supreme Court rulings, the story was far from over. It seems like almost as soon as the ink was dry on the Thornhill decision, other court cases started coming along and chipping away at it. It created what you could honestly call an incredible shrinking right. And you can see on this timeline just how fast it happened. Just 1 year later, in 41, the court said, well, picketing can be banned if there's a history of violence. A year after that, they ruled you can only picket right there at the business you're arguing with. By 49, if your goal was to get someone to break another law, your picketing wasn't protected. And then the really big one came in 1957 with the Vogt case, which gave states a whole lot more power to put limits on picketing. So you might be asking, how did the courts justify walking this back? Well, they came up with this really important legal idea called speech plus conduct. The thinking goes like this. Picketing isn't just someone talking. It's speech plus the physical act of patrolling, which is designed to put economic pressure on a business. And because it's speech plus conduct, the government gets more leeway to regulate it than it does with pure speech. So how does this legal theory actually play out in the real world? Well, the line between a protected and an unprotected strike came to a really dramatic head in 1981, and it involved the President of the United States. This was the famous PATCO strike. The air traffic controllers were federal employees, and that's the absolute key here. There was a specific federal law on the books making it illegal for them to strike. They'd even taken an oath promising they wouldn't. So when they walked off the job, President Reagan didn't just see a labor dispute. He saw a direct violation of federal law. He went on TV and gave them an ultimatum: be back at work in 48 hours.
And when they weren't, he fired them. More than 11,000 people lost their jobs. And he could legally do it because their strike was considered an unlawful objective. That's the exact kind of exception to Thornhill that the courts had been carving out for decades. Okay, now let's fast forward to a much more recent presidential example, which raised a totally different kind of challenge to the right to strike.
So, in August of 2024, Donald Trump made this comment suggesting that if private company employees go on strike, their bosses should just fire them. As you can imagine, that immediately set off a firestorm and led to legal action from unions like the UAW. Now, this is where it gets really important to put the two situations side by side. Reagan was dealing with federal employees whose strike was already illegal under the law. Trump was talking about private employees whose right to strike is generally protected by law. Reagan took direct action. He actually fired people. Trump stated his support for firing workers, which is what prompted the UAW to file an unfair labor practice charge against him. See the difference? And this is the legal bottom line. For most workers in the private sector, the National Labor Relations Act explicitly protects their right to strike. That means firing them for it is, in most situations, against the law. This makes the whole context of Trump's comments fundamentally different from Reagan's actions against the PACO strikers. Which, of course, brings us all the way back to our big question. After this long journey from Byron Thornhill's arrest to presidential politics, where does the right to picket actually stand today? Well, at the end of the day, the right to picket is still a core free speech right, born directly out of that Thornhill case. But it's not absolute, right? It's a right that is constantly being shaped and reshaped by this one central tension. Where does pure speech end, and where does conduct begin? From a quiet picket line in 1940s Alabama to the presidential campaigns of today, that question is as relevant as it's ever been.